family violence directed at a spouse can be very harmful to kids, both in the short term and the longer term. For example, they can have a greater risk of psychological harm, increased instances of aggression and anxiety and depression or behavioral problems. There are a number of provisions that have been added to the best interest considerations. Family violence is specifically defined, but very broadly defined, and includes, among other things, psychological or emotional abuse and I mentioned this point earlier, direct or indirect exposure of a child to family violence. It does not include, and this is specifically found in the definition, use of reasonable force to protect oneself and others from harm. It also protects family members, including relatives living with the family, so it's broad in that sense as well. Family law clients must reach agreements that ensure a child's safety, security, and well-being. Lawyers have professional responsibilities to assist their clients in making such agreements. I suggest to you that a lawyer must investigate whether there is in fact family violence at play in a particular case and consider its implications. A lawyer should do so at an early stage in the process, as the information is critical to a determination of how the dispute ought to be effectively and fairly resolved. This isn't just a wild and crazy idea of mine. As you know, the Law Society Code of Professional Conduct, the new one, comes into effect on January the 1st, 2013. That code includes requirements that I suggest respectfully involve determining whether family violence is an issue, and if it is, its nature and impact. Under the code, and again the sections are all in the paper, a lawyer has a duty to the client to obtain sufficient knowledge of the relevant facts before giving advice and before recommending dispute resolution options. A competent lawyer must investigate facts, identify issues, ascertain client objectives, and consider possible options. A lawyer should encourage out-of-court resolution whenever it is possible to do so on a reasonable basis. And a lawyer has a duty to advise the client to avoid or end litigation, but only whenever the dispute will admit of a fair resolution. So all of those responsibilities under the code need to be considered in light of not just the goal of early resolution in family cases, but the dual goals of making sure that resolutions are fair, taking into account family violence. Those responsibilities, of course, would apply to all family law matters, including those that involve the Divorce Act. And my final point, which is not on the screen, relates to the Law Society Task Force report that we heard about this morning that just came out on September the 7th with respect to mandatory education requirements. We've heard what the requirements are if it's dealing with dispute resolution, with arbitration and mediation and parenting coordinators. With respect to lawyers advising a party in relation to a family law dispute, which will include everybody, the Law Society Task Force has not recommended mandatory training. Instead, they recommend that the Law Society, and I'm quoting, should alert lawyers to the obligations found in Section 8, and that lawyers should be strongly encouraged to take courses in screening for family violence.